Hello, everyone. Welcome to Court with Krissy. Time for an update. Jury trial is tomorrow, and this is the real final pre-trial. Also, near the end, we hear the judge's decision on the medical records. As always, if you missed the first appearance, link is in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
Courtroom, there are three files, 247158, 7178, and 7184 FH. Final pretrial date. This matter is scheduled for trial tomorrow morning. Ms. Karen J. Davis Roberts appears on behalf of the defendant. Mr. Alexander Bahani appears on behalf of the people. And Mr. Bahani, you may proceed.
Thank you, Your Honor. Would the court like me to take these motions in the order in which they were
Please.
filed? So then, Your Honor, we begin with the people's motion to limit the scope of expert witness testimony. The people rely on our written pleadings here. But as the court is aware, the defendant has filed a expert witness notice, submitted a curriculum vitae, and has also complied with the court rule as to a summary of testimony as to what she expects from her expert witness. However, Your Honor, the summary of testimony includes quite a bit of material that is outside the scope of the witness's expertise. The witness's curriculum vitae indicates that he is a board-certified emergency medical physician and has extensive experience in the practice of emergency medicine. However, quite a bit of the expected testimony has to do with the fields of neurology and neurosurgery. And in fact, Your Honor, the court will ultimately hear testimony that the victim in this case was transferred out of Huron County by the emergency room physician at McLaren Thumb Region because he needed treatment that was specialized, that being neurological treatment and neurosurgical treatment. However, the expected testimony here, again, the people rely on our written pleadings as well as the exhibits attached, but this falls far outside of the scope of expertise of an emergency room physician whose primary purpose is to make an initial differential diagnosis, stabilize an individual for treatment, and then refer them to specialized care, which is exactly what happened in this victim's case when he was transferred to McLaren Lapeer Hospital. He was evaluated by another ER physician there and immediately turned over to the neurology and neurosurgery service in that hospital. So we're asking for an order to be entered that limits the expert's testimony, if he is qualified to be an expert at trial, that his scope of his testimony be limited to the field of emergency medicine.
Thank you. Ms. Roberts, your response, please.
Yes, Your Honor, thank you. The prosecutor is claiming that Dr. Cruz, who is board-certified ER physician, is somehow not qualified to testify regarding neurology or neurosurgery issues. Dr. Cruz will not be challenging any neurological treatment provided to Stevens. His testimony will assist the jury in understanding the complex terms and medical findings of Mr. Stevens' injuries. He's qualified as a board-certified ER physician, which encompasses all systems of the body. He is the first physician that a person meets subsequent to some type of traumatic injury, either physical or psychological. It is Dr. Cruz's assessment which determines the overall treatment, blood work, and tests that are needed, like CAT scans or an MRI. His analysis is crucial. He decides when and if it's appropriate to put the patient, for instance, like Mr. Stevens, in a cervical collar in the event that there's some kind of damage to the cervical vertebrae from the fight that had ensued. He has indicated he was supposed to, and he did, evaluate the neurological status, which was evident in the medical records. And he said it was, and the Dr. Blaker, and by the way, I apologize, I had listed Dr. Blaker as Dr. Blakely, throughout my response, and that was incorrect. And it was up to the analysis of Dr. Cruz to determine part of Mr. Stevens' confusion, which also could have been a result of his ETOH level which was 116, and the normal is 0 to 10. Dr. Cruz's expertise in the diagnosis and treatment and management of acute traumatic injuries is crucial to this case. As part of that, of his evaluation and what he said he would be testifying to, he explains an in-depth explanation of the traumatic brain injury, which was sustained, which was merely, and I say merely because it was very small, a post-concussive syndrome. And he also explained the pathological processes involved, and that is well within his area of expertise. He's worked in a level 1 trauma center for over 20 years. This description of a traumatic brain injury, or TBI, is always noted as mild, moderate, or severe. And that is standardized knowledge, and that's knowledge that Dr. Cruz has. It's not based on any opinion. It is based on defining characteristics. He's more than qualified to provide his expert opinion regarding the ER piece of this testimony. And the neurological portion, as that expertise exists in parallel with the neurological and neurosurgical evaluation. They are not mutually exclusive. While Mr. Stevens was sent to, I think it's McLaren General or McLaren Lapeer, that's where he was treated by a neurosurgeon and neurologist. However, he is not offering any opinion on those records, and my understanding is that Dr. Blaker will just be testifying about the emergency room evaluation and treatment. He will not be
Dr. Blaker or the other doctor?
Dr. Blaker. Initially, Dr. Blaker will just be testifying. That's the people's witness.
But I thought you were referring to Dr. Cruz. I got you. Okay.
He will not be testifying about anything that happened at McLaren Lapeer, only about the ER. And he also was the one who determined that Mr. Stevens should go on to McLaren Lapeer to be evaluated for a very small 2 to 4 millimeter contusion, which, although there was initially some kind of leakage in the brain because of the fight, it was not significant. It was something that he wanted, Dr. Blaker wanted follow-up on. Dr. Cruz's testimony will definitely help the trier of fact to understand the evidence and determine a fact and issue. It is also important that the jury clearly understand that Stevens' physical injury was not one that could, quote, seriously harm the health or function of the body. And Dr. Cruz's testimony will confirm that. Based on all that, I'm asking that the court deny the people's request to limit Dr. Cruz's testimony.
Anything else?
I'm sorry?
Anything else, counsel?
There's nothing else, Your Honor.
Okay, rebuttal.
Your Honor, the very point of an expert witness is that they carry an expertise in some particular field. The CV that has been submitted by Dr. Cruz would indicate that he is an expert in the field of emergency medicine. However, while that may touch on neurological and neurosurgical matters, upon immediate diagnosis or immediate interaction with a patient in the emergency department, the entire point of having other specialties of medicine is those individuals are experts in those fields. And to have Dr. Cruz testify about mild versus moderate versus severe traumatic brain injury, or having testified as to the question of Mr. Stevens was confused at the scene, but remembered everything that happened at a hearing nearly 2 months later. Is that possible? Dr. Cruz is not involved in the long-term care of individuals with traumatic brain injuries. 2 months later would indicate long-term care. Emergency medical physicians, by definition, are acute care providers. They are the first and the immediate care providers for individuals before they are referred to a specialty that deals with their specific illness or injury. The testimony that is expected from Dr. Cruz will exceed the scope of his expertise. And Your Honor, the people point to our filing with the criminal jury instruction that Ms. Roberts seems to believe that we have to prove that a serious injury did take place. That's not necessary in this particular crime of assault with intent to do great bodily harm. Only the intent is required pursuant to the jury instruction. The intent to do great bodily harm, not actual great bodily harm. So Dr. Cruz's testimony would simply confuse the jury if he's going into detail about whether this is an injury that is serious or significant, because it's not necessary for the people to prove that. Thus, Your Honor, we ask the court to limit the scope of his expert testimony to his field of expertise, that being emergency medicine.
Thank you.
Your Honor, if I may briefly reply, Mr. Pahane seems to be confused about an emergency room physician and what their role is. Of course, they have to determine whether it's a mild, moderate, or severe brain injury. That's part of their expertise, so that they can then determine what other kinds of treatment are necessary. And that's what Dr. Blaker did. He thought that the small contusion in the cerebrum was significant, so he referred him to McLaren Lapierre. And that's what he did. That is part of what an emergency room physician is doing. Dr. Cruz has no intention, nor did his summary provide any such suggestion that he would be discussing anything about the long-term treatment of a TBI. The only thing that part of his testimony would include is that Mr. Stevens could not remember things at the time of the ER evaluation. He continued to say he was confused. He wanted things, he couldn't remember what happened. And then miraculously, 2 months later, he remembered everything. It is well within Dr. Cruz's expert testimony to explain to the jury that it is not possible for someone to not remember anything from the incident itself, but to then go on and remember everything supposedly in detail 2 months later. And I think that's well within his level of expertise, contrary to what Mr. Pahane is saying.
All right. Well, as far as the court's concerned, I'm making it very simple. If it involves emergency medicine, if I'm not mistaken, Dr. Cruz is or was a teacher at Wayne State University. I mean, the accolades go on and on regarding his emergency room care. If it involves emergency room care, that is fair game because it's within the province of the particular witness's expertise. However, to be able to explain to the jury that it's not possible to not remember everything from from the incident prior to, but then remember 2 months later, I find is well beyond the scope of an emergency room physician. That would require a neurologist or someone specialty in that field. The doctor can testify regarding the injuries that he may have observed as a part of his emergency medical room care. But when it comes to explaining that there's no possibility regarding memory in this incident, I think that's beyond his scope. However, if it's established that that the witness can be qualified in that in the form of qualifications, that's fine. But from what I read on the CV, it's not. I'm granting the people's motion at this time. However, if a foundation can be established at trial, so be it. But I'm granting the people's motion. Next motion, Mr. Connie.
Yes, Your Honor, this is the people's emergency motion to suppress evidence due to violation of reciprocal discovery. The people filed their initial request for discovery in these files on July of 24, September of 24, and October of 24. On December 13th of 2024, current counsel for the defendant filed for appearance in this matter, replacing predecessor counsel. In fact, on April 28th of 2025, counsel for the defendant's paralegal came in person to the people's office here in the Huron County building to review all 3 of these files to ensure that her file was complete. On May 27th of 2025 at 4:01 and 4:15 respectively, the people received 2 emails from counsel for the defendant entitled Exhibits and Additional Exhibits. Attached to these emails were 10 digital files containing screenshots of text messages, medical records, and a handwritten note. This is the first instance that any of these materials were provided to the people, and the people cite MCR 6.201 as the controlling court rule pertaining to discovery. That rule indicates, Your Honor, that discovery must be complied with within 21 days of a request. Now, the response from the counsel for the defendant, Your Honor, quite honestly, I've never seen anything like this in my legal career. This is nothing but a tirade, an insulting tirade listing my name repeatedly over and over throughout when I represent the people of the state of Michigan. Why my name is listed so prominently in this particular filing is beyond me, but it is filled with inaccuracies. So first of all, Your Honor, the counsel for the defendant agrees that she came onto this case in December of 2024 and received files from predecessor counsel. Plus, our office has provided her files at every single request. It was after the 4th request for the same document, Your Honor, that Ms. Roberts and I had a conversation. And I invited her to come to our office and inspect our files, that they are completely open for her inspection and she can have copies of anything she wanted. I made an aside comment that each month that I'm at the Attorney Grievance Commission, I see prosecutors who are being referred to the commission for discovery violations pursuant to Brady and Giglio. And I told her at that time that I was not going to be one of those prosecutors and that I wanted her to come and look at our files. Now, she turns that somehow into some sort of threat and some sort of bullying, that I mentioned the fact that prosecutors are brought before the commission each month for failing to comply with discovery. If anything, it's a warning to me, Your Honor, because I don't want to be one of the prosecutors who had a case pending before the commission that didn't give the defense attorney everything. But instead, she responds that it would be ridiculous for her to drive 3 hours from her office to come and inspect our files. Your Honor, that is the effective representation of her client, is ensuring that she has a complete and total file. But Your Honor, that doesn't really have anything to do, I mean, really, her whole response doesn't have anything to do with the people's motion. The fact is, she didn't comply with discovery until 1 week ago. Well, 1 week passed, last Tuesday. We received 10 exhibits for trial that the people are asking for an offer of proof. Ms. Roberts replies that she doesn't know what offer of proof we're talking about. The offer of proof that we would ask Ms. Roberts to provide to this court, if she received those exhibits on the day that she sent them to us or within 21 days of receiving them for us, then she's complied with discovery. But the people find it difficult to believe that all of a sudden, 1 week before trial, She discovered all of these exhibits and immediately complied with the discovery order and sent them to us. That's hard to believe when this case has been ongoing for months. Your Honor, she indicates that apparently, in order to comply with Rule 6.201, that it would breach her attorney-client relationship and that we are asking for privileged communications in asking her to comply with MCR 6.201, and nothing could be further from the truth. Those rules for attorney-client communication and MCR 6.201 are not in conflict, Your Honor. Now, Rule 6.201J deals with violations of discovery. The court has broad discretions under 6.201J as to how to handle a violation of discovery. Your Honor, it cannot be contested that the people filed our discovery demands in these cases in 2024. Ms. Davis Roberts came onto the case in December 2024, and 1 week ago, tomorrow, she complied with the discovery order that the people submitted. Your Honor, so what we are asking, because trial is set for tomorrow, is for these exhibits that were sent last Tuesday to be suppressed.
Remind me again what these proposed exhibits are.
There are a number of screenshots from a payment application, cell phone payment application. There are a number of text messages. There is a handwritten note from one of the parties in the case, and there is a set of medical records.
All right, is that it?
Thus far, Your Honor.
Okay, thank you. Ms. Roberts, your response, please.
Well, it's interesting that Mr. Pahani is claiming that he's never seen anything quite like my response. And likewise, in my 35 years of practice, I've never had such an acrimonious relationship with a prosecutor like I have with Mr. Pahani. During the time that I've been on the case, I have made repeated requests for different discovery because there were a lot of things that were missing in Mr. Talisman's files, including things like exhibits, which I have asked the prosecutor in numerous emails and on the phone having to do with their exhibits, since they were mentioned in the preliminary exam, which was exhibit 2 through 30 something, 32 or whatever, which I have never received. As far as my paralegal, Miss Seal, coming in to view the discovery, that was after, like Mr. Pahani did say, after a phone call. And I do that we had together. And during that phone call, he explained about the grievance. And I still believe today that it was to intimidate me. Maybe that wasn't his intent, but it sure felt like it on my end. And I've been doing this 35 years. There's only been one other time that I've had that kind of comment from a government prosecutor, and that was an assistant U.S. attorney. And I even then considered it to be a form of intimidation. When Miss Seal came to look at the file, she went through it, and I said explicitly to her that what I wanted was for her to see if she could find any kind of exhibit list. She could not find any exhibits. What ended up happening was she flagged a few documents. They were not copied. The clerk or whoever was working with her, and I'm not sure who it was at that point. It might have been Miss Krug, I believe. She sent them to me by email. She didn't send them to me. Miss Seal did not incur any kind of copy charges as is claimed by the prosecutor. As far as the documents that were sent to him, these are documents that will be used to impeach the credibility of one of their witnesses. It's not to establish any fact having to do with any of the evidence in the case other than the witness's issue of credibility, which she has considerably. The documents that were sent, one was a list of money that my client sent to one of the witnesses, and they were just listing money that he sent by Cash App. That's all it was. And that's just that would be part of his testimony because he will be testifying. As far as the handwritten note, it's really innocuous. It was a handwritten note asking to have communication with my client while he was in jail. That was it. There's nothing substantive in anything that I've said. There has been no prejudice shown by the prosecution because there is none. As far as when I received them, these were discovered during my trial prep, and as soon as it was my determination that they might be helpful, I sent them to the prosecutor immediately. I didn't have them when he claims that I should have. I've done a lot of discovery work that predecessor counsel did not, and have come up with some documentation. And like I said, it's only to impeach the government's witness. And what's interesting is on Friday, I received a note from the prosecutor's office stating that they're sending me this document having to do with Mr. Talisman while he was incarcerated at the Sand Lake County Jail, and the fact that he supposedly shoved some of his cast into the toilet in the cell, causing it to back up. This was sent on Friday. And I asked why I was receiving it, and it says to impeach your witness. And I said, which witness? I mean, first of all, it's not relevant at all. So here is, as the old saying goes, the pot calling the kettle black. That's inexcusable. I've asked for a summary of Dr. Blaker, summary of his testimony, and the only comment that I've gotten is that Dr. Blaker is going to testify to the treatment that he gave to the sorry, strike that, not the defendant, to the victim, Mr. Stevens. There were numerous claims that challenged, I believe, in the way I read it, that challenged me as an attorney and my credibility, saying that if in fact I said that I received these documents the day before I gave them to him, that it would be false. As far as I'm concerned, he's calling me a liar. I don't know how else you would describe it. Nothing in the exhibits that I have suggested, and I'm not even sure that I needed to send them to him, by the way, but there's no prejudice. like I said, they're to challenge the credibility, the veracity of one of their witnesses. I have not ever, in my 35 years of practice, ever violated any reciprocal discovery order, and I'm not about to start now, although I can tell you this probably will be my last trial. The discovery that I have sent will only illuminate any inconsistencies that the witness may have. It's not outcome determinative. I'm asking that these be allowed. And if they are, if the court decides that they should not be allowed, then I'm also asking that this little piece of paper regarding what my client allegedly did in the jail and backing up the toilet, that not be allowed either. So I'm asking the court to deny his motion.
Mr. Bahani, final copy, please.
Your Honor, this is the pot calling the kettle black. The pot filed a motion and the kettle did not, Your Honor. The problem herein is that these emails came and they're labeled exhibit and then additional exhibit. And there's no description as to what they are. Ms. Roberts indicates that there's no prejudice to the people. These are digital exhibits that cannot be authenticated by the people overnight. We don't know who the text messages are between because there's no description of what these exhibits are in the email. They were simply files attached to an email. So we don't even really know what we're looking at. The Cash App pieces that we saw, screenshots from Cash App, that was obvious. We could determine what that was, but these text message conversations, no idea. No way for us to authenticate. But Your Honor, I think what counsel says really boils down the entire issue here and makes this decision easy for the court, because she indicated to the court repeatedly that these exhibits are not outcome determinative. In other words, they are not here to prove or disprove any particular fact that is in question. That, Your Honor, makes them extrinsic evidence. And extrinsic evidence for the use of impeachment is not permitted. These exhibits cannot be admitted as evidence in the trial if they are truly extrinsic evidence being used to impeach a witness's statement. Therefore, Your Honor, we're asking the court to grant our motion to suppress.
All right.
Your Honor, just very briefly, Mr. Pahani claims that you can't tell anything about these text messages. It's very clear in the text messages. It's very short. I mean, I think there were maybe 4 text messages that I sent that all had to do with the credibility of what Ms. Lavalette has testified to in numerous judicial proceedings. And it's different than what is on those text messages. There was only, I think, 4 of them, maybe 5. I'm not even sure about that. The majority of the exhibits, the potential exhibits that I sent to Mr. Pahani had to do with the Cash App. And the rest of them had to do with testimony that was different than what Ms. Lavalette has already testified to in 3 different proceedings. Of course, they're important, and there's no discovery rule violation here, and I think that they should be asking the court that they be allowed to remain as exhibits. And again, if in fact that's the case, of course, there's no explanation by Mr. Pahani why I received this piece of information report from the jail about my client somehow stuffing part of his cast down the toilet and making a problem so that the toilet was backing up. I'm not sure why he sent that, but surely should not be allowed if in fact you're not going to allow my exhibits to come in.
Thank you.
Your Honor.
Mr. Mahoney, final argument.
Yes, Your Honor. The people sent over a disciplinary report from the jail to Ms. Roberts on Friday. We did not send an exhibit. We do not intend to admit that as an exhibit, as Ms. Roberts does with the items that she sent to us. Frankly, Your Honor, this goes back to an argument that we had in a prior hearing, in that Ms. Roberts cannot relitigate the personal protection order that was already decided by this court. And if she's trying to indicate that any party in that particular hearing was lying to the court or lying during that time, that matter has already been litigated and it has already been closed, and it cannot be relitigated in the middle of Mr. Talisman's trial. Thank you.
I'm sorry. What are you talking about? What are you talking about that needs to be relitigated, Mr. Pahani?
Is she directing her comments to me, Your Honor?
Sounds like she is.
Well, I would ask, does the court want me to address her directly?
Well, I'm just wondering where we're going. I mean, all of a sudden, now we're talking about a personal protection order.
Well, Your Honor, if the statements that Ms. Roberts is making lead the people to believe, because she's saying that in at least 3 judicial proceedings that she has made false statements to the court. Well, there's only been 1 preliminary examination in this matter, and the only other times that Ms. Laviolette was ever before the court was for a personal protection order. And so the issue has come before the court before, in that personal protection order was heard by the court, ruled on by the court, closed by the court. And to take facts that may have been presented to the court during that hearing, personal protection order hearing, or during the proceedings leading up to the personal protection order, are barred. It's that proceeding is over and done with, because all the people have to show at trial for a conviction for aggravated stalking is, was there a valid personal protection order in place at the time of the alleged conduct? That's it. What happened in the court's personal protection order hearing, the people can't say, but it's not subject to relitigation in the middle of a trial for a completely separate issue. That's the point that people are trying to make, because of the comments that the counsel made, leading the people to believe when she's talking about 3 separate interactions, those are the only other 2 that the people can think of apart from the preliminary examination.
All right, thank you. Well, I'm going to make a ruling. The issue before the court is whether or not some evidence that, or proposed evidence submitted by the defense to the prosecution should be excluded for not being timely provided pursuant to MCR 6.201. Under MCR 6.201, mandatory disclosure, paragraph A2 is in play. Any written or recorded statement, including electronically recorded statements pertaining to the case by a lay witness whom the party may call at trial, except that a defendant is not obligated to provide the defendant's own statement. What the court has heard is some documentation and maybe a note and some other information that was discovered by defense counsel. Defense counsel in turn turned that over to the prosecution. Prosecution's position is it's too late. You should have done that a lot earlier. And there was some suspicion as to whether or not it may have been held on to and not turned over timely. On the flip side, defense counsel said when she was preparing her trial preparation of this matter, she discovered these things and immediately turned that same information over to the prosecution. So obviously mandatory disclosure is in effect for both parties pursuant to A2. There's more information or more requirements by the prosecution under B, but that's not applicable here. And clearly it was not turned in 21 days prior to or the 21-day requirement. And I'm not going to get into the middle of an allegation of, well, you knew about it, but you didn't turn it over versus I turned it over immediately. Both are officers of the court. So frankly speaking, to me, it's a moot point in the fact that I'm accepting counsel's statements as counsel statements. And there's no unfair surprise or prejudice that the court has heard other than the fact that it was turned in late. So should have been turned over earlier had it been discovered, but that's the way it is, 6.201. So it passes 6.201. However, The information provided by the defense, according to defense counsel, is regarding impeachment. And what is also in play is MRE 608. Under 608, witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible. Well, I don't need to go with that. Part B, though. Except for a criminal conviction under 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. But the court may, on cross-examination, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of the witness or another witness whose character the witness being cross-examined has testified about. So clearly, extrinsic evidence is not allowed for purposes of the rule under 608 relative to truthfulness or untruthfulness. Specific instances of conduct, again, goes to that fact. And here in this case, I don't know exactly what all this information pertains to, but it's not being offered for I should say for evidence for the court, for the jury to consider. It's offered apparently for some form of impeachment. If it is used for impeachment purposes and I find it's extrinsic, it's not admissible. It won't be admissible. It can't be admissible. You can use impeachment evidence. It may be used to attack the credibility of a witness, but it's not entered into evidence because it is not offered for the truth of the matter asserted. It pertains to, again, alleged character flaws with the potential witness. At the end of the day, it may be inquired into, but the use of extrinsic evidence is not admissible. That's what the rule says. That is the ruling the court has. However, if it's entered for cross-examination purposes and it's probative of truthful and character, truthfulness or untruthfulness of the witness, it can be inquired into, but that's it. It doesn't go any higher than what the rule requires. Inquired into only. Otherwise, it's inadmissible. That's my ruling.
So, just so I understand, Your Honor, I want to make sure I understand this. So if I use it under 608B, it's will be allowed?
No, you can ask about, you can inquire into it, but to actually attempt to admit it beyond inquiry is beyond the rules required. You have to, and I know you know 608B, but that's what it is. It can be inquired into, but that's as far as it goes.
All right, I understand. I do have a couple questions, though, not relating to this, but to other rulings one ruling having to do with medical records.
Yes, I was going to inquire into that as well. I have them. I've reviewed them, and the court, I'm not going to go into what the medical records say because I don't want to have any issues relative to HIPAA. The court took a look at the medical records in question, and according to my review of the records, these particular records occurred prior to the charges being authorized in this case. So I don't see any relevance to it unless you wish to make an offer of proof, Ms. Roberts, because I'm not seeing anything other than a typical Stanaway type of issue.
The offer of proof would be what it was that she told the doctor, the reason that she had the fractured ribs. Usually when they come in and someone is met, for instance, in an ER, they want to know, why are you there? And that would have been, she would have told the doctor that she fell. And that's the reason, which was different than what she said in the PPO. Again, this has to do with her credibility. And the other one had to do with the repair of her ACL, and that had to do with another incident with my client, but had nothing to do with any kind of physical violence. And she would have told the doctor the reason that she's there for the treatment that she's seeking. Those are the only two things that I was looking for.
All right. Mr. Bahani, any comments?
And Your Honor, again, this goes back to the people's prior comments about relitigating the PPO. Counsel has stated that she wants to impeach statements that this individual made during the course of obtaining a PPO from this court. That matter was already heard. That matter was litigated. All parties had an opportunity to litigate that matter at that time, and the court made its decision. To go back in time prior to this incident is not only irrelevant, Your Honor, but bringing in this individual who is not a listed victim in the case, bringing her medical records up would certainly be a stand-away issue as far as the people are concerned.
Anything else, Ms. Roberts?
Nothing, Your Honor.
Okay, thank you. Again, these occurred prior to the alleged incidents involved in this matter. I find no relevance to it. The medical records will not be included. The question is, what do I do with them? They're on a digital status. I may have to return them back to the hospital. I don't want to have any issues. But that is my ruling relative to that as well. Anything else we need to address before tomorrow morning?
One brief housekeeping issue from the people, Your Honor. On 307178, when we filed the amended information some time ago, when we moved the aggravated stalking case to another case file, our computer program defaulted the venue on the information to out of county and Huron County. The people need to submit a corrected information in that file to indicate Greenleaf Township and Sanilac County in 307178. When we reprinted it, it defaulted to
Out of county.
The computer's out of county setting is we have to manually enter that when it's out of the county. So we would ask permission to submit a new information with the only changes being Greenleaf Township rather than out of county and Sanilac rather than Huron.
Any objection to that, Ms. Roberts?
None.
All right. So let's present that tomorrow morning.
Thank you, Your Honor.
Today. Any other issues we need to address? Ms. Roberts?
Your Honor, as far as the criminal jury instructions, will those be discussed tomorrow?
I'm in the process of compiling them now, and I hope to have some preliminary instructions for your review. I don't go into detail regarding the specific instructions up front regarding the elements of the offense. I just bring the elements of the offense in the initial instructions, but when it comes to the final instructions, when everything is provided, we go through that rule by, we go by basically instruction by instruction on the record.
So that we'll discuss that during the...
Yeah, before it goes to the jury, absolutely, we'll be going through all the instructions. And we do that on the record as well.
Okay. 9 o'clock tomorrow?
Yes, if you could be here a little bit earlier, I'd greatly appreciate it because I'd like to start on time. Not to say you're going to be late, but we'd like to have you here so we can proceed accordingly.
I'll be there early.
Thank you. I appreciate that. All right. We'll see everyone tomorrow morning. That'll conclude this matter. We'll go off the record. Thank you.